I wanted my two big topics for today are an introductory lecture for constitutional law, so you can see a little bit about what the courses look like. You can get, a look into what you would be doing every day. And then I'm going to talk about essay writing because that is the primary way, or at least a primary way, in which you are going to be assessed. And so that's what you're going to need to be able to do by the end of the course. Okay, so I'm going to talk about constitutional law. Constitutional law is really divided into two areas. The first is the structure of the government, right? You're going to learn how the federal government in the United States works, the allocation of power between the three different branches of government, judicial, legislative, and executive, and then the division of power between the states and the federal government, or federalism. Then the second half of the course, we move on to individual rights. So these are things like due process, the right to liberty, freedom from government control, equal protection, which deals with discrimination, primarily on race and gender, and then freedom of speech and freedom of religion, which I think are fairly self-explanatory. What I thought I would start with today is something at the very beginning of the course. We would cover this on day one, after we looked at an introduction to the Constitution and constitutional history. We start with the power of the courts. And so we start out by looking at, well, what can courts do? And we find that in the United States, as probably everyone is aware, the courts are extremely powerful in that they can rule that laws are invalid, right? Congress passes a law, the president signs it, and the Supreme Court can come in and basically say that law is not valid, it can't be used because it violates the Constitution. So that makes it look like the Supreme Court is in charge of the government. But it's not, of course, right? We have three different branches of government. They all have a unique role, and the power of the court is limited in a number of important ways. One of the most important ways in which the power of the court is limited is what we call the case or controversy requirement. The idea here is that the courts can only decide concrete cases, controversies between litigants, right? They're not allowed to just step in and give advice to the president or say to Congress, you know what, don't pass that law, that would be a problem. Why don't you change it to this? Because if the court did that, if it could render advice, or what we would call an advisory opinion, then the courts really would be in charge, right? They would be telling the president and Congress what to do, advising them on how to amend things, and they would be calling the shots. We don't want that because the Supreme Court is not elected, right? The Supreme Court, these are judges who are appointed for life. Now, they're appointed by the president, confirmed by the Senate, but they're not really political actors, right? We don't want them to set national policy. Instead, we want them to just enforce the Constitution, impose limits on what Congress and the president can do, but not actually tell them what to do specifically, right? That needs to come from Congress and the president. So the case and controversy requirement embodies this by making sure that the courts don't step outside of their lane, right? They continue doing just what they're supposed to be doing without expanding that out in taking over the role of the other branches. Now, in constitutional law, we always talk about this at the beginning. Where does the law come from? Well, it comes from the text of the Constitution, but the text of the Constitution is very short. This is the Constitution, which I guess you can't see because of my blurred background. There we go, right? It's a really small document. This is the entire thing. And so we always look for the text, but it never really gives us a concrete answer to complicated questions. But this is where the text points us. That's where we always start. And it says the judicial power extends to cases and controversies. Doesn't say anything else. So judicial power only goes to cases and controversies. The court then tells us, what does that mean? Well, for it to be a case or a controversy, we need to have standing. The case needs to be right, it cannot be moot, and it cannot be a political question. All right, so those are 4 different topics that we would cover. Today, I'm just going to look briefly at the first one of standing. So with standing, we're asking, do we have the right parties? Are these the proper individuals or companies to bring this case in federal court, right? Because we don't want someone with no connection to the case to bring the litigation. They're not going to have the incentive to litigate it properly. And more importantly, then if anyone can file a case about any complaint, it would limit that case in controversy, make it meaningless. Because you could file a lawsuit saying, well, I don't like the fact that my tax dollars are being funneled to X or Y, and the court would look at it because there's no concrete interest in the case. Well, we don't want that. We want them to actually have a reason to be in court. So the standing rule tells us that the plaintiff must have an injury, right? Has to have an injury in fact, concrete and particularized, actual, not abstract or conjectural. So it has to be something that concretely affects the plaintiff. They can't just share, an injury of dignity or offense that would apply to everyone. Usually it's money, right? They lost money, but it doesn't have to be. Next, the second element here is causation. The injury has to be fairly traceable to what the defendant did. So we're actually looking at both, do we have the right plaintiff and do we have the right defendant? And then finally, you have to ask, what is the plaintiff asking the court to do? What is the remedy that is being sought? And can that remedy actually resolve or redress in some way that injury? So there's three requirements here: injury in fact, causation, and redressability. That's our rule, right? So I started with the context. Why do we have the rule? Then I give you the rule. The next thing we would do is use cases as an example, what the court does with that rule. So the case, I'm just going to cover this very quickly. We would spend more time on this in class, and we would cover, I think, 3 different cases on this issue. But just to give you an idea here, the case is Luan versus Defenders of Wildlife. Luan is a government official. He's being sued. Basically, the government is being sued by an environmental organization, the Defenders of Wildlife. What they're saying here is that the federal government is not properly enforcing the Endangered Species Act. Now, among other things, the Endangered Species Act requires the government to essentially conduct a study before it engages in a new construction project, just to see, is this going to hurt endangered animals? Could it lead to an extinction event? Just so we know before the construction starts. Think you're going to create a dam on a river. Was that going to kill migratory fish? Well, the way the government is interpreting it in this case, it is only looking at domestic projects within the United States. But of course, the United States spends money everywhere, right? And it gives money for foreign investment projects as well as domestic. And so the environmental organization here files a lawsuit saying, government, you need to do this even internationally. So if the government is going to cut a check for them to build a dam, not in California, but in some other country, then we should look, is that going to hurt endangered animals? That's what the plaintiffs are saying. The government, of course, is saying, no, we shouldn't have to do that. And so you always need to look, what is the plaintiff concretely asking for here? Well, they're asking for a judgment from the court in order saying, government, you need to change how you interpret and apply this law. Well, the court ends up saying there is no standing. There is no standing because none of the elements are met. There is no injury in fact. What the court means by that is the environmental organizations are not concretely injured by funding foreign development projects, right? This is a domestic environmental organization that is solely composed of US citizens. And, they just don't have a concrete injury. There's no way in which this particularly harms them. So, let's look at what the plaintiff argues, their contentions here, which the court rejects. Injury number 1, they say, well, we get sad when animals are extinct, right? We're an environmental organization. We care about animals. And this is an injury to us because, well, it's upsetting. The court says, no, that's not a concrete injury. That is the definition of an abstract injury. Everyone is sad when animals go extinct. There's nothing special about you. It's not concrete, it's abstract, it's not particularized. Injury number two, they say, well, some of our people go and visit these countries, and if the animals go extinct, they won't be able to do that anymore. The court says you need to be specific. If you had someone who was studying an animal, let's just say that they're, I don't know, in the Congo or something, and we're worried that an animal is going to go extinct. Well, if they're just saying, well, 10 years ago I went and I visited the animal, that's not good enough. You have to show, no, I'm going to do it 3 weeks from now. Here's my plans, and here's the project that is going to displace those animals. You need to be specific. You need to be concrete. This idea that I might try to view them in the future is not good enough. And then finally, they say, well, some of our members work in zoos and they study the animals in captivity. The court says, so what, basically? There's no way in which the wild animals going extinct affects the population in the zoo unless you can show that they were planning on capturing the wild animal that was endangered and put it in the zoo, which of course they generally don't do. And so again, that person would be sad if the animal goes extinct, but they wouldn't be personally affected in a concrete way. So the court says there's no injury. It goes on to say, even if there was an injury, there's no causation or redressability, because we don't know if any project would actually be defunded if we had one of these studies, right? Maybe it would, maybe it wouldn't. Just because we have a study does not mean that necessarily the projects would be defunded by the federal government. They might decide to go ahead anyway. And more importantly, if the federal government pulls out funding, well, maybe the home country just increases funding, or someone else steps up and donates more money, right? The United States doesn't really run everything, obviously. Other countries are going to be involved too. And so there's no way in knowing whether or not this would actually solve the injury or even redress it at all. Okay, so that, again, very quickly is a rundown of the case, an example of how the court would apply it. The next step would be to look at hypotheticals. And I would go through these with you to test your knowledge of the law, but also illustrate particular points. Now, for the interest of time, I'm not really going to go through these with you in any detail. But this one is getting at just that basic idea of injury. Right? Let's say a plaintiff is filing a lawsuit saying he doesn't like that his tax dollars are going to foreign aid for war, right? This is a peaceful protester, someone who doesn't believe in war. Well, tough. There's no standing there. You're not injured in a concrete and particular way just because your money is going to Ukraine or Israel, right? You're not affected in any way that is different from anyone else. And it is not affecting you in a concrete way. It's just that money is being spent in a way that you don't like. That's abstract. Now, it's abstract, unlike number two. Number two says Congress passes a law making everyone go to church on Sunday. Well, with that issue, everyone is affected, but everyone is affected in a concrete way, right? You individually have to go to church, so you are hurt. Right? So it's not just that everyone is affected in the same way. The problem with number one is it's abstract. There's not a concrete harm. This is different. And then number three, this is the one that students find the most counterintuitive and that we spend the most time on. This is a case. This is a Lyons case from the 90s out of California. We have a plaintiff who was arrested. When he's arrested, the police choke him, they put him in a chokehold, and he suffers serious injuries as a result, like permanent injuries. The court, he sues the police, says that was excessive force in violation of the Constitution, the Fourth Amendment, and the court says there's no standing. if you stop and think about that for a minute, if we were doing this in class and we had plenty of time, I would, try to get you to give me the answer. But just, as we're flying through this, the problem here is redressability, right? He's seeking an injunction, asking for the court to tell the police not to put him in a chokehold. Well, the court says, yeah, there's an injury, right? He was physically harmed. It was caused by the police, but it's not going to redress a future injury to give this forward-looking injunction, for the simple reason that this individual is unlikely to be arrested and choked a second time. Most people are never put in a chokehold by the police, right? I never have been. No one I know has been. And so the court says this was an unlikely, an unusual event. It's not likely to happen again. And so you're not going to get an order from the court telling the police to never do it. All right, then, we might have even more hypos on something like this. Then we would have an essay. And this essay is usually something I would ask you to do outside of class so that we don't suck up class time on it. But, sometimes it's simple like this one. Sometimes it's more involved. Typically, the first unit, I'll have something relatively simple. It'll build on itself and get more complicated as we go. So this is just an example. I'm not going to go through it, but then I always have a model answer, and I offer to give feedback on anyone who wants to email me their answers.